Hi, everybody. My name is Jonathan Hinman, and I'll be presenting on Interlake Reserves Tribal Council et al. And Government of Manitoba. That's a 2021 case from the Manitoba Court of Appeal. So jumping into the facts of the case, in response to massive flooding in 2009 and 2011, Manitoba built a temporary emergency outlet channel to direct floodwaters from Lake Manitoba to Lake St. Martin, and then onto Lake Winnipeg. In 2011, rains led to flooding of Lake St. Martin and flooded reserve lands in the Interlake region. In 2019, the province proposed to replace the temporary channel by building two permanent 23-kilometer-long flood management channels from Lake Manitoba to Lake St. Martin, and then from Lake St. Martin to Lake Winnipeg, called the project. In addition to consultation with Indigenous groups, the project was subject to federal environmental assessments under the Environment Act and the Canadian Environmental Assessment Act, now called the Impact Assessment Act. Interlake Reserves Tribal Council represents 4 of the First Nations involved in consultations and whose reserve lands are located on or near Lake St. Martin. Those nations are Dauphin River, Kinogeoshtigan, Lake Manitoba, and Little Saskatchewan First Nations. IRTC argued that the project seriously threatened the exercise of their various Section 35 rights, namely through impacting wildlife migration, destruction or degradation of plant life used for food and for traditional medicine, impact to fish habitats, depletion of land for hunting, trapping, gathering, and camping on, loss of traditional knowledge of animal migration, loss of cultural identity acquired by exercising treaty and Aboriginal rights, and loss of physical, mental, and spiritual benefits associated to exercising those rights. Here's a map showing a zoom in of the area. So here, of course, we have Winnipeg on the southeast corner, Lake Winnipeg on the right, Lake Manitoba on the left. Zoomed in here, we have Lake St. Martin. The highlighted areas here in yellow are the reserve lands of the various First Nations just mentioned. And the area in blue here is the Dauphin River. It's showing the direction proposed to redirect floodwaters. So in the event of flooding on Lake Manitoba, the flow of water would go into Lake St. Martin and then into Lake Winnipeg towards the east. Okay, so facts and judicial history. The IRTC argued that insufficient consultation efforts were undertaken towards accommodation. They sought interlocutory injunctions for 3 separate administrative decisions that were integral to the project. The first was a permit for land clearing. The second was a license to upgrade a service road. And the third was review of an order in council by the Minister of Conservation dismissing IRTC's appeal for the road license. The motion judge granted 2 injunctions. The first enjoined the province from undertaking work on the service road, and the second enjoined it from all other work related to the project. On appeal, Manitoba sought to have the injunction set aside, arguing that the motion judge erred in his application of the test for granting an interlocutory injunction. On these pictures here, we have an example of some of the flooding from 2011 that was mentioned earlier. And on the bottom picture here, this is the temporary channel. You can see it does quite a bit to the forest area there. So the main issue before the court was, did the motion judge make a reversible error in his application of the legal test for granting interlocutory injunction such that both injunctions should be set aside? Disposition was that the interlocutory injunctions should be set aside and were by the Manitoba Court of Appeal. The analysis for the court's decision is as follows. Injunctions are an equitable remedy. Normally, a judge's decision to grant an interlocutory injunction is entitled to a high degree of deference on appeal. Appellate court judges are not to substitute their discretion for that of the lower judges, absent a misdirection in fact or law or a finding of clear injustice. As many of us may know, the legal test for granting an interlocutory injunction is set out in RJR McDonald Inc. The 3-part test is: first, there needs to be a serious issue to be tried. Second, irreparable harm to the moving party must be demonstrated if the injunction is not granted. And third, an assessment of the balance of convenience. The court looked to the reasoning in Hudson Bay Mining and Smelting that the steps in the RJR test are not individual hurdles, but interrelated considerations in making an assessment. Strengths of one factor may compensate for weakness in another. The court found that they could not grant an injunction on the basis that no meaningful consultation had occurred. The record of consultation was voluminous, and contested. The court found that the motion judge misdirected himself on the second branch of the test, the issue of irreparable harm in both injunctions by first, in the first injunction relying on general assertions rather than specific evidence, and two, in the second injunction, failing to apply the stricter test for a quia timet injunction as per Sapotawayek Cree Nation. However, the court declined to expand on whether the misdirection incidental to the questions of irreparable harm would amount to allowing the appeal, citing the motion judge's application of the third branch was clearly sufficient grounds to allow the appeal. The appellate court found that the motion judge's approach to the third branch of the RJR test, the balance of convenience, was deeply flawed. So what does the third branch of the RJR test for granting an interlocutory injunction involve? Question of balance of convenience hinges on a determination of which of the two parties will suffer greater harm from the granting or refusal of the interlocutory injunction, pending a decision on the merits. The motion judge provided very limited commentary on his reasoning for the question of balance of convenience. A motion judge's reasons expressly or by implication must demonstrate that there has been a reasonable weighing of the catalog of harms, not only that what an applicant claims will occur if the interlocutory injunction is refused, but also the countervailing harms that the respondent will suffer if it is granted. In the appellate court's opinion, that did not occur. So how did the motion judge err in applying the third branch of the RJR test in both injunctions? The appellate court found that the motion judge erred by not considering expressly or impliedly assessing the interests of parties not before the court and the wider public, namely the city of Winnipeg and surrounding residents. The project was not commercially motivated, but rather was made out of an interest to preserve the residents and property of Winnipeg from flood damage. The work surrounding the road license to service the project was not subject to environmental assessment under the federal statutes. The road access rather was necessary to maintain the temporary channels and to complete the construction that was still under assessment. The motion judge erred on the facts in finding that it wasn't necessary to clear land to drill boreholes. His assessment relied only on the fact that such holes had been drilled without clearing in the past and did not consult expert evidence on whether they were required in the new round of work. The Canadian Environmental Assessment Agency argued that the clearing for the boreholes was necessary this time around. The court found that the motion judge should not have substituted his discretion for expert evidence on the issue. Ratio. So why is this case important? This case delineates some of the limitations that exist around interlocutory injunctions, especially in regards to development projects and Section 35 claims. Interlocutory injunctions are limited forms of relief. Motion judges cannot grant an interlocutory injunction as they would simply see fit. A motion judge is constrained in granting an interlocutory injunction in that first, a motion judge cannot grant the remedy in a way that is unreasonable with regards to the application of the test set out in RJR McDonald or unsupported by the facts. Second, a motion judge cannot substitute their discretion for expert evidence. Third, a motion judge must also take into account the interests of parties not before the court and must explain their reasons for coming to their conclusions. As an interesting side note at the conclusion here, a recent case was decided in the Manitoba Court of Queen's Bench this past June that held that Manitoba was responsible for damage caused in 2011 by flooding in the Interlake region because of another older flood diversion project, the Portage Diversion. Cottagers, farmers, and others around Lake Winnipeg whose properties were damaged were able to make claims. A question for thought is, how might this case impact future litigation in relation to the Lake St. Martin projects? That's my presentation. Thanks for listening.